It's Entertainment Law Update, episode 173 for October 30th, 2024. Hi, everybody, and welcome to another episode of Entertainment Law Update, where each month we pull together our roundup of legal and business news stories and share our opinions and commentary and analysis. And we're glad to be here with you. Tamara's especially glad, and she'll tell you why in a second. But from Los Angeles, California, I'm Gordon Firemark.
And aloha, calling in and videoing in from Hawaii today, I'm Tamera Bennett.
Maui wowie, Tamara.
Maui wowie, that's right. The good news is with the time change, we're knocking this out before I lose too much time on the beach today.
There you go, great. And no implications about that other meaning of Maui wowie here, by the way.
Oh, okay, yeah. So I know not what you discuss.
Yes. So you've been there for about a week. You're enjoying yourself, having a good time. You're not sunburned.
I am not sunburned. It's kind of like I come back from the beach vacation and everybody goes, "Did you go to the beach?" But you know what? Enjoying it. It actually has been. I know we hate discussing the weather, but kind of been cloudy. Yesterday was it was a car day, not so much a beach day. Okay. Got to go to the Surfing Goat Dairy, which was super fun. They have all these. Anyway, it's a goat farm where they make fresh cheeses and all kinds of things, and went to the top of Haleakala. We've been multiple times, and this is the first time we've ever been socked in with clouds.
Oh wow! Okay.
Yeah. So.
Well, I'm sure many of our listeners are appropriately jealous of you. And,
let's just say I was having a text conversation with my pastor and sent him a picture yesterday, and he's like, "Please do not provoke your pastor to jealousy."
Isn't that one of the deadly sins?
So I shall tempt not. So.
Well, okay. So let's preview. We have a coming event next month at the end of October. At the end of November, November 20th through the 22nd. Sorry, I will be at the UTCLE conference, the Entertainment Law Institute for the Texas Bar CLE program. Are you not going to make it, or are you going to be there?
I am unfortunately not going to make it. I will be virtually attending. So that's the cool thing. I mean, we would love everybody to attend in person, but please note this has virtual attendance. For the Wednesday, it's a half day, kind of a 101 CLE segment that I believe can be paid for separately. And then Thursday and Friday is full day CLE. There is pre-approved CLE credit in more than a handful of states, including Texas, Tennessee, Georgia, several others. So that to me, holding bar membership in both states makes it really nice because you just don't have to go through the extra hoops to get your credit. So, join us virtually. I haven't done a virtual through this CLE provider before, but I think they have online chat and communication. So, if we do, I'll try and pop in and chat with folks if they want to or whatever.
And I'll be presenting about the unions and the post-strike sort of shakeout of last year's strikes, and that'll be interesting. I probably ought to get cracking on pulling that presentation together more than just the outline I'm sitting with now.
Yeah. So, lots of really fun topics, and I will say I think it's Friday afternoon, not Thursday afternoon. I'll have to check the schedule, but there's going to be an interview with Terry Lacona, who has been the producer behind the full 50 years of Austin City Limits television show.
Wow.
Yeah. So they just had this is their 50th year of Austin City Limits on PBS. And he's going to be interviewed about that as a segment. And super excited. I know Terry, and I've worked with him on other projects outside of ACL. And in addition to all of the legal things we're going to be discussing, that's going to be a really cool conversation.
I hope my travel plans don't make me have to leave early for that.
I know that often happens to me, but I've just got A lot of moving parts going on that last week.
Yeah, sure.
Or that week of November. So I just finally canceled my hotel.
Gotcha.
And said it's just not going to happen. So.
All right. Well, I'll be there to wave the entertainment law update flag.
There you go. Thank you. Do that.
All right. Well, we should jump into our rundown. We've got a couple of big cases and some other smaller but interesting ones. So let's start off with, I think it's pretty big news about Two Live Crew. And they're reclaiming their masters from the record label. This is Little Joe Records versus Ross. And they were reclaiming their sound recordings from the 1990 deal. They had made a Section 203 termination of transfer notification that permits creators to reclaim their works after 35 years. And, it's designed to protect artists. Exactly this scenario, right? Who had signed away their rights when they were had less negotiating power and leverage, and so they may have signed some less than favorable deals. So Luke Campbell, the surviving member of the group, along with the heirs of Mark Ross and Christopher Wong Wan, issued this notice of termination, and they've been fighting over it. The master recordings were transferred. Well, they were transferred to Luke Records, and that's a record label owned by the tax lawyer who represented the label back in those early days. Anyway, he had bought the recordings out of bankruptcy after the band had gone bankrupt, I guess in the early 2000s, and he bought them for $800,000. So they filed their notice, and Weinberger contested the validity of the notice, saying that the bankruptcy ended their right to terminate, that they had forfeited the termination right by declaring bankruptcy, in the 90s. The judge, though, didn't agree. He said, no, the congressional intent behind termination rights is to protect the artists, not to protect corporations or third parties that might be benefiting from their creative work. And he said, these rights are inherently personal to the authors, and they can't be transferred or lost through bankruptcy. So that was a big ruling. That was early in October we saw that. And the case then was clear to go to trial. And after what sounds like it was a fairly quick, short trial, the jury came back and found that Campbell, Ross, and Wan they were not employees. It was not work made for hire in the days that they made those contracts. So they were actually, that was the remaining issue, I guess, for the trial. So that it wasn't a work made for hire. So it was susceptible to the Section 203 termination.
Yeah, I think this is big case law on a couple of fronts. On the bankruptcy issue, we see bankruptcy. I need to go back and look. There was a case in Texas, not related to terminations, but related to bankruptcy and the ability to get the actual physical master recordings out of bankruptcy. And Cindy Lazari, who is passed away, and we actually, the Sports Entertainment Law Section of State Bar Awards gives an award in her name, because she was the one that really fought for artists to be able to recover those assets, that intellectual property asset out of bankruptcy. So, there's all kind of this ongoing over the years litigation regarding what happens to these copyrights when they go into a bankruptcy. But from a termination of the grant, I'm like, how could that be subject to bankruptcy? Because the right has not vested yet when the bankruptcy occurred. Yeah. So I don't even know. I don't think the judge discussed that. Maybe the judge did. I mean, I agree with the ruling from the judge, but I think it revolves around the fact that the right hadn't vested. So I don't think you can cut it off when it's not vested yet.
Well, I wonder if, and I don't know, I didn't read the case that carefully either, but I don't remember, was Two Live Crew an entity of some sort other than a partnership agreement kind of thing?
So what I did look at was the jury verdict instructions and form, and it specifically listed all three band members. Okay, and said yes or no. Did they create this within the scope of their employment as a work for hire? Okay, and the jurors all selected no on all three tick boxes.
Okay. Yeah.
So it was not a question of an entity when it came down to the jury verdict form.
So we might see a different outcome in a situation where the members of the band had formed a corporation or an LLC,
and they had done a loan out.
Yeah. Well, or even, or just been recording under the LLC at the time that they were, as employees of the LLC at the time that they were making the record. Then the record, anyway, so
we would see a difference because that was the Waits case, right?
Right. Yeah.
Because he records on,
he used
you guys forgive me if I've just said the wrong case, but I'm pretty sure that's the John Waits case where he did everything through his loan out, not related to bankruptcy, but related to his claim for termination. And the court came back and said, if these services were provided through your loan out, then the termination provisions don't apply.
So maybe another argument for artist representatives to think very carefully about how and when to form entities to house the band. Certainly for touring, you probably want to have an entity that controls that aspect of things. But we already know most of the time they don't do publishing under a group entity. And now recording is another component of this that we need to be thinking about. I think a lot of deals do make the records under the entity. So
they do, and I've had this conversation with numerous attorneys just because they're not aware, and a lot of people weren't aware until we got these decisions that this was going to be an issue when the courts did their interpretation and application of the termination provisions under 203. And I suspect also under Section 304, it would be the same analysis. So.
Well, interesting. I mean, the other area that is interesting is for bankruptcy attorneys to now be, and creditors to be looking at what's the real value of these things that were created and in a record deal or something like that. I don't think Weinberger would have wanted to pay nearly $1 million for those masters if he'd known that this could happen.
I'm just wondering as well, we don't know what all the testimony was in front of the jury. If he was a good witness, just because of all of their relationships over the years.
Well, and it actually may, sometimes it hurts the case that some of the witnesses are no longer around to testify, and sometimes it maybe helps.
Could be. So we have one more to add to the list of where we are finally getting a body of case law related to copyright grant terminations. They've been, again, these notices are filed every day and deals are struck, but very few of these go all the way through to litigation where we get a ruling to rely on.
Great. Yeah. All right. Well, let's go on. Do you remember, you and I both were, I would say we grew up in the Atari generation, right?
Yes.
You remember the Crystal Castles game?
Okay, so I don't.
Okay, I don't really either.
I just wasn't a big. I remember my cousins coming to visit and bringing this contraption and hooking it up to the TV.
Yeah.
So we are really dating ourselves.
Well, the Crystal Castles was actually one of the games that was in arcades, so
it was in arcades. That's right. So, it was in arcades, kind of like we had Pac-Man in arcades. And who knew that 6 seconds of advertisement for poor old Jake and State Farm could lead to a lawsuit?
So the case is Atari Interactive Inc. versus State Farm Mutual Auto Insurance Company, out of the Northern District of Texas from the end of September 27th of 2024. So you want to fill us in on the facts?
Yeah. So we've already alluded to this, but is it game over when State Farm is sued for copyright infringement over a 6-second advertisement? Atari Interactive sued State Farm, as we said, in the Northern District of Texas, which is my normal district. But, I could probably be for the District of Hawaii, but that's an aside.
I'm all for it.
They were sued for copyright infringement, alleging that the use of Atari's iconic Crystal Castles arcade cabinet design in a State Farm advertisement was more than a de minimis use. Atari claims that the ad featured a modified version of a Crystal Castles arcade cabinet. State Farm changed the name of the game that pops up on the center of the screen to Witch's Brooms on the cabinet's marquee, but left portions of the game's original artwork that was on the cabinet box visible. The defendant, State Farm, moved to dismiss Atari's claim under a Rule 12b-6 motion, asserting the use was protected by fair use and that Atari had failed to state claims for unjust enrichment, business disparagement, unfair competition, and violations of the Texas Insurance Code. That was a unique one to put in there, but anyway, we'll see. On the de minimis use, Atari argued that the arcade cabinet design featured prominently in the advertisement was recognizable. So that's interesting when you ask me if it was recognizable to me. Mm-hmm. To how many people is it recognizable, and does that matter? I don't know. Yeah. The court found that unlike previous cases where the use of artwork in the background was considered de minimis, the cabinet in this instance was central to the scene and was easily identifiable to viewers. Therefore, the court ruled that the use was not de minimis, allowing the claim to proceed. The defendants put forth their fair use defense and went through those. The court went through the 4 factors, starting with purpose and character, finding that it was a commercial use. Clearly, it was part of an advertisement, even though it was only 6 seconds long. There was no transformation to the use, and so that weighed in factor of Atari. Mm-hmm. Nature and character of the copyrighted work. Atari's work was used for its expressive elements, those visual designs, rather than for any factual content. So that also weighed against fair use. The amount and substantiality of use. Even though the marquee was altered, that wasn't enough. It was still identifiable as Crystal Castles. So again, going against State Farm. Effect on the market. Atari's allegations that it has a robust licensing business made it plausible that the unlicensed use of the design could harm its market, especially if others did the same thing. So again, weighs against fair use. So none of the factors favored the defendants, and the court denied their motion to dismiss on fair use grounds. But then they kind of scoop up all the other claims that were brought and said, you're out of here. Yeah. So this is, I don't know if this is the law in every state on unjust enrichment. But the defendants moved to dismiss Atari's unjust enrichment claim, arguing that Texas law does not recognize unjust enrichment as an independent cause of action. The court agreed, citing several precedents. So it's got to be related to something else. Business disparagement. Atari claimed that the ad portrayed its products in a negative light when Jake from State Farm hit the cabinet, allegedly suggesting that Atari's products were unreliable. Didn't show sufficient facts for that. Nor did they find that there were lost profits and damage to the reputation because that occurred. Unfair competition was based on the same facts, and that didn't hold up either. So that was dismissed, as well as this kind of novel Texas Insurance Code claim.
Misleading statements in an ad for insurance. Okay, I sort of see the thinking behind bringing that claim. But to me, it seems like the court is just saying, look, you got your copyright remedy. Take yes for an answer, and the rest of these are out.
Right. We're just going to kick the rest of those out and move forward on the copyright. It is, I guess, kind of interesting me to think about this being a 6-second audiovisual work. That ad is down. I think both of us have seen a screenshot of the ad, and I suspect the design. Now, it's not the design of how the cabinet; it's the artwork on the arcade game cabinet is there for the whole 6 seconds.
Yeah,
and that's it. Well, so I don't know what they'll come back with on was it enough to survive summary judgment? I think so. But was it really? Does the fair use defense?
Well, it's interesting. I mean, if you think back about the cases dealing with artwork in the background, there was the Ringgold case involving the poster of the quilt in the background of the TV show Rock for, I mean, it was like 7 scenes, but it was 2 seconds here, 2 seconds there, and that one went for the against a finding of fair use. It was found to be copyright infringement. So this one, I think we chalk this one up as another lesson for the art directors of the world to know that you have to do more than just change the sign or the title on the thing. To me, it feels de minimis, but
to me too. And I guess they could have, State Farm perhaps could have achieved the exact same purpose just by having an arcade game and putting their own artwork on it,
or stripes, or just triangles, or geometric shapes that aren't copyright material.
Yeah, their own original, whatever it is they wanted to put on there, and it probably would have conveyed the exact same thing.
So this is another one I have to add to my checklist, because I do film clearance, where the producers will come and say, anything we need to think about here, and I'd hate to think now I've got to start asking the question, oh, are they playing a video game in the scene? We better check the side of the video game.
Yeah, but you look at just any number of films, TV shows where they're in an arcade.
Right. Exactly. Showing all of the different games. I mean, and Atari probably had half of them at the time,
Right.
So, I mean, in this case, it's very commercial use, not an expressive work. So that, I think that factor weighs differently in a feature film than it does in a TV commercial. But it sounds like that was not an important factor in the court's thinking here.
Yeah, I guess I'm actually thinking back to many movies from the 80s where that would have been
the opening scene of War Games has Matthew Broderick playing Space Invaders, and my guess is they probably cleared Space, because I was actually showing the gameplay.
Yeah.
But I mean, it was so ubiquitous. What's interesting is that a movie about the modern era wouldn't have video games, those kind of video games in it. Everybody'd be sitting there on their phones, right?
Right, or on their couch at home.
So it's a genre.
Yeah.
I rewatched Fast Times at Ridgemont High the other day, and it has lots of those kinds of scenes.
It has lots of, all of those movies have lots of those scenes where they're at the arcade. I will tell you, War Games came out when? 84, maybe? Okay. I love the War Games. So, watched it when Brock was maybe 10, 11, 12. It still kind of held up as a really good movie, even though it's, it was interesting to go back and watch it many decades later to kind of see. But you're right. Yeah, it's key to that. We've come a long way from.
Yeah. So nowadays, a filmmaker might use a video game or arcade or something like that as a point of setting the time frame that the movie is supposed to occur. So it is still something we have to think about. I didn't mean to be dismissive of it as the cell phone thing, but anyway.
Well, no, but maybe that is more transformative because it's evoking.
Yeah.
It's the nostalgia factor.
Yeah. It's interesting.
I don't know.
Well, I think it is something that we who do clearance work need to start thinking about. And by analogy, other things that may show up, I don't know, if your character is holding something, sort of a prop kind of a thing, do we have to clear that, whatever thing that is an iconic symbol of a time from, that, I mean, you try to anticipate all these problems, but I don't think anybody thought Atari was going to come out of the woodwork over the squiggles and design on the side of the Crystal Caves box.
And here's what I'm thinking. Had this been an ad that was running on broadcast TV cable, 30-second ad, 15-second cut down, whatever it is, they probably have a full clearance procedure. I'm wondering, because this was a 6-second campaign, digital campaign, that it didn't go through it. I don't know. We're just speculating, because that's what we do.
Yeah. Ad agencies have to think about, okay.
Yeah. Okay,
Well,
so we have talked.
Go ahead.
I was going to say, we've talked tattoo artists a lot. What's the latest on this?
Well, we have a new appellate decision. This time it involves Take-Two Interactive and the World Wrestling Entertainment. It's an appellate decision in a case we first talked about a month or two ago. I think it was originally decided, actually a year or two, back in 2022, when the jury said that World Wrestling and Take-Two have to pay this tattoo artist, Catherine Alexander, $3,750 in damages for recreating tattoos that she made on pro wrestler Randy Orton in the WWE 2K video game series without her permission. So the defendants appealed and tried to overturn the jury verdict. And even though the denial of fair use finding stands, what we have here is a Pyrrhic victory. Is that the right phrase? The fair use analysis went like this. The court thinks that the defendant's use of the tattoos was clearly commercial. So there's your purpose and character. It's a create a superstar feature that allows users to take the tattoos and apply them to their player avatar and those kinds of things. So it was included for its expressive value, not merely to display Orton's likeness accurately. Next up, the nature of the work. Obviously, the art of creating a tattoo entails creative and expressive efforts. She testified about all the creative process that went into it. The amount taken, it was the whole tattoo. Pretty straightforward there. The evidence that trial establishes the defendants had previously altered other tattoos of wrestlers in order to avoid this very situation. And the market impact that the court says this factor weighs in favor of the defense because she had never licensed her tattoos for video games or any other medium. The defendant's expert also provided unrebutted testimony that the market for that kind of thing really doesn't exist. So, but on balance, they found that, it wasn't a fair use. But on damages, the court said she presented no evidence at trial that would support that amount of money as the damage award. No evidence of a hypothetical lost license fee or the value of the infringing use to the infringer. The expert from the tattoo artist said he believed a portion of the sales and profits of the video games were attributable to the tattoos in question because they needed Orton as one of these characters in the game, and he needed to have his tattoos. But the other, but didn't conduct an analysis of how much of that would be the appropriate amount. The another expert didn't offer an opinion on damages. So basically, they said, no, you're not getting any meaningful damages. And the court held that depicting tattoos in video games could be infringing, but future plaintiffs are really going to have to show that they've registered their copyright so they can get the statutory damages or prove the market. So when I said Pyrrhic victory, I mean, yes, you win, and no, you don't get any money.
Right. And all of attorney's fees, court fees, all of that.
If not a registered copyright.
That's right. So I guess the practice pointer I understand that tattoo artists, depending on how prolific you are, you probably aren't going to file a copyright application for every design you come up with. Could you potentially, do a group work of designs? Or if you're putting ink on famous people, file those.
Yeah. Or when your past clients become famous.
That's right.
It's still not too late. It's before the infringement.
It's still not too late. It's before the infringement because... And I also wonder if they hadn't had the ability where during gameplay, you could take the tattoo and apply it to somebody else or apply it to yourself or whatever. If that was not going on, would she have even won? Otherwise, would it have been fair use because he was portrayed accurately? And I believe we've had those rulings, correct? Where if the tattoos are part of the accurate portrayal of the person, it's not an infringement. So, yeah, I think it's keeping up with if you're actually designing tattoos on people who are athletes, entertainers, performers, then maybe you really need to think about filing a copyright application for them.
Yeah. I just had the bizarre thought that is it possible a hairstylist who comes up with a really creative hairstyle for someone who becomes a famous athlete or is a famous athlete. Could that be another this kind of a case? I hope I didn't give some plaintiff's attorney an idea.
I mean, that's interesting.
Less fixed, I think. But
if it's say it's a wig.
Yeah, good point.
Could that not be a work of sculptural art?
Well, in theater, wardrobe designers and wig designers and makeup designers, they sometimes do copyright their designs. So that's certainly
I've never thought about that before. But if you had some really unique, obviously you have to get it away from the usefulness,
right?
Utilitarian aspect of it to be protected by copyright. But
I don't know. Is a wig a useful article just because it would covers
your head? But I think if you have a very unique,
I'm thinking design. Of that Flock of Seagulls haircut, from that artist. Those kinds of things. That's really kind of almost outlandish, I guess you could say. It's an interesting notion. Just something to chew on.
Okay, when the Flock of Seagulls. I know. We went to an 80s reunion.
Mm-hmm.
Hours and hours of 80s music reunion a couple of years ago.
Yep.
He has no hair now.
Is that right?
And nor did he pull it out as a wig just to make me feel like it was the 80s.
Okay.
So anyway.
Why don't we talk about UMG recordings versus Grande? I think we talked about this, last month or the month before?
We did. Are okay. Gigi?
Yeah.
We're skipping over?
No. We're not skipping. Are we skipping a case there? Oh, I did. Yes. Well, let's do
it.
Okay. So let's talk about Gigi Hadid defaulting in her copyright lawsuit over an Instagram post. So what's going on here is one of those many cases where a celebrity grabs a photograph that appears on social media, republishes it on their feed, and gets sued by the photographer. In this case, Gigi Hadid is the celebrity in question, and she's been to court before on these kinds of infringement claims because she's posted pictures of herself without the permission of the copyright owners, typically the paparazzi. Here, in those cases, she won in at least one of those cases, and she settled a couple of the others. But obviously, was spending probably hundreds of thousands of dollars on legal fees. So, in August of 2023, she was sued for posting the photographer in this case is Ulysses Ramales. It's a picture of Bella, her sister, on social media. So she posted this picture taken by Ramales on social media without permission. And when he sued her, she just defaulted on the case, didn't show up for court, didn't respond, nothing. Let the judgment default. The court awarded Ramales $3,000 in damages, which is a fraction of the $30,000 he was asking for. $1,140 in attorney's fees, $440 in costs. So for what would have just been a basic retainer just to talk to a lawyer, she's out of the case, having paid off the judgment in the neighborhood of $5,000.
Yeah. So then the question is, why did she do that? Did she really not know she was sued? Clearly, there must not have been any question on service because the court ruled.
Yeah, I mean, the court said it was difficult to rule on her recklessness or knowledge of the infringement without her being present. So she took the risk of being a willful infringement that trebles damages or whatever. But I think it was a calculated risk that she took. She just said, look, it's going to cost me less to pay off whatever damages he could actually prove or get than it would pay me to fight and either win or lose.
So this is interesting. The judge did not award statutory damages. Even though if he brought a claim for did he bring a claim for $30,000, which would have been the minimum statutory claim?
No. Statutory damages minimum is $750.
Oh, that's right, $750. You're right.
$30,000 is the max.
If they can show $750 in damage, right? Yeah, willfulness.
Right. So he's asking for $30,000 in damages, which is the maximum under statutory damages. But the court decided, no, it's not a maximum damages case. It's a pretty minor one. I think it's a little bit of a statement by the court too. Hey, you're wasting our time here.
It's Well, we're going to talk about this at the end. It's almost one of these kinds of claims you think would have gone through
the CCB.
The CCB.
Yeah. I have to wonder, did they approach this photographer and say, will $2,500 make this go away? Something like that. And he said, no, I want 30 grand. So he took it to court, and well, okay. So he gets something, but it's certainly not going to cover his legal fees.
Right. And it's hard as the representing the copyright owner stance is to say, why am I working so hard if the artist can just, or can just go take my image and use it?
Right. Yeah. I mean, the court's clearly saying photographer's right, but he's also saying, not going to make an example of her with that kind of money damages in this case.
We're gonna give you a licensing fee. It's about what it worked out to be.
Yeah, I mean,
because he was probably able to show this is what I make from licensing these images.
That's probably where the judge got its ideas about the number. Anyway, you have to wonder. I mean, maybe the attorneys didn't do a greatest job in presenting evidence of willfulness or something like that, but they weren't asking for big, treble damages from the willful infringer side. So yeah, you prove what you can prove, I guess.
Right.
Okay, now let's talk about UMG versus Grande.
So I feel like we've been talking about this case for a while, but major record labels, including UMG and others, sued Grande Communications for contributory copyright infringement, claiming the ISP, Internet Service Provider, knowingly allowed subscribers to use the ISP's services for infringement, despite over 1.3 million notices, I guess from Rights Corps, who was their service to provide those notices. After a jury found Grande liable and awarded $46.8 million in damages, Grande's motions for judgment as a matter of law and a new trial were denied. But on appeal, the Fifth Circuit upheld the verdict, but found the statutory damages should be calculated at a per album, not a per song rate, because the Copyright Act treats all parts of a compilation as one work for statutory damages purposes. Thus, the court vacated the damages award and remanded for a new trial on damages. Now, the last time I kind of remember talking about that was years and years and years ago in one of the mp3.com cases where the court came back and said, this is a per album, not a per single calculation rate. So I think this will be one we really need to be watching now that we're in an age of singles again.
Yeah, right. I mean, maybe I think it changes some internal ways of doing business at record labels, but it's the independent artists who, they don't want to spend 10 times as much to register their copyright, so they register the album.
And but here's the other thing. Now there's certain limitations of how many tracks can be on one registration, depending on how you do your registration. So you may have to file more than one to get everything captured. So maybe that's beneficial, but you're still filing a bundle, a group of tracks that were published together on one recording. I don't know. It's definitely going to make me rethink my recommendations for clients on how we should do that.
Another area where it comes into is in a fair use analysis. If it was one song on an album, it's 1/10 of the whole work.
Right.
For the amount and substantiality analysis. So I think that, at least for me, I think it weighs in favor of individual registrations if you have the resources to make that happen. Registering, you can still register the album as a compilation also. I don't know what the value really might be. For me, this, podcast episodes, same question. Do you register each episode?
Photographs.
Or photographs. Well, photographs, there's that exception that allows for unpublished works. You can do folios. I don't think the same rule applies because it's not treated as a compilation.
Okay, because you can, maybe that's it, because that seems
pretty
severe if you published every you're a professional photographer, you file
Hundreds
a
of
copyright
photos
application.
a month, right? Yeah.
That's right. And you do them, everything captured in the month of August.
Yeah.
So
yeah. I mean, what are the odds that someone's going to infringe on 3 or 4 from one same month's worth of work? Maybe it's a calculated risk again, but
yeah.
This seems like, well, look, if listeners don't think that this is the way it should go, if people feel like, no, the law isn't fair when this, if you're going to give us the right to register it as a compilation, any of the single compiled works should be fully protected. Hey, write to Congress for all the good that's going to do. But I guess I'm pretty cynical about Congress accomplishing anything anymore. But
well, I think that's if you're a member of trade organizations that have a voice.
Right.
That's who you need to be talking to say, this is an issue.
Yeah.
We need you lobbying for us to get this changed.
Yeah, and I think that there are organizations in the music industry. The photographers are well represented. Yeah, and the authors guilds, all of them.
Right.
So, I hate to think of, just if you publish a compilation as an artist, let's say you're a poet, and you write 25 poems in a book that you put out. It would be a shame if one of them gets infringed and you can only claim, I'm sorry, if 10 of them get infringed, somebody circulates the whole book, same issue. Right. Is it 10 or is it 1? So, or 25 is one. So,
but troubling. If you had just a book, and we took one chapter versus 10 chapters. I mean, but that then goes to the amount of substantiality, I guess. But
some works are capable of standing alone, and some aren't. Chapters of an individual book may not be. So the nature of the work is a factor.
Yeah.
Not just for fair use. So, anyway, something to be thinking about and talking about with our clients, of course, and how to register and those things. Let's move on. Let's talk about this Lanham Act case involving. Would you have ever thought we'd be talking about rubber shoes on this show? So the case is a false designation of origin case involving Crocs. It's the Court of Appeals for the Federal Circuit from October 3rd, a precedential opinion regarding application of Section 43A of the Lanham Act. The case starts as a patent infringement lawsuit brought by Crocs against Double Diamond Distribution and its affiliates, including Dogs, Inc., DAWGS, Inc., and Mojave Desert Holdings, which is going to be collectively called Dogs. After Crocs sues Dogs for patent infringement, they counterclaimed, alleging that Crocs engaged in false advertising under the Lanham Act. Specifically, that Dogs contended that Crocs' claims were about the product's material, marketed as Croslite, and describing it as patented, proprietary, and exclusive, misled consumers regarding the nature and qualities of Crocs footwear. Dogs argued that these representations created the impression that the products were made from a unique material distinct from that used by competitors, and thereby implying that other brands offered inferior alternatives. Crocs said, no, this doesn't warrant a 43A kind of an action because there are precedents in the Daystar case and Baden Sports Inc. versus Molten USA. In its ruling, the district court took Crocs' side, saying the terms in question were related to claims of inventorship rather than the product's nature or characteristics. Well, they took it up on an appeal, and the court, what is CAFC? That's the appeals panel for patents, I think, right? They scrutinized the district court's interpretation, particularly focused on the notion that Crocs' claims were fundamentally about false designation of authorship rather than a misrepresentation of the product's qualities. And they concluded that Dogs' allegations directly related to the nature, characteristics, and qualities of the shoes, and therefore did fall within 43A1B. So the court emphasized that the false assertion of a patent couldn't be considered in isolation. You have to look at the broader context where consumers are misled about attributes of the product. So they reversed the district court's summary judgment, determined the lower court had erred in the dismissal of the claims, and Dogs gets to proceed I guess with its defensive offense. So the CEO of Double Diamond Distribution says this is a victory not only for his company, but for fair competition and consumers that were adversely affected by Crocs' alleged deceptive advertising practices. And Crocs, of course, said the opposite, that it was a big disagreement and that they are evaluating options for further legal action. When you look at a pair of Crocs, do you care whether it's patented material or a patented design for the shoe?
Okay. So when I first became aware of Crocs, I don't know when Crocs came out.
Yeah.
More than 10 years ago?
At least, yeah.
15 years ago, probably.
Mm-hmm.
I kind of feel like we were told they were patented and unique and there was nothing else out there like a Croc.
Okay.
I don't personally own any Crocs. I remember my young child at the time, just that first pair of Crocs was like a huge deal.
Yeah.
So, so I do have a real recollection at that time of thinking this is something new and unique. Nobody has anything like this. And now everything that's come after that is a knockoff. So maybe we were misled. As an average Joe consumer.
I mean, certainly there was a patent on the design of the shoe, right?
So they had a design patent.
Well, I think that's what this case is really about. Is you're calling it a patented shoe or patented, and you're referring to this brand of material, the Croslite product. I don't think it said it was patented Croslite material. I think it said patented Crocs shoes, or something like that. So I guess it depends on how you worded your marketing and advertising. Again, maybe I'm speaking out of turn here, but I don't know that whether the material is patented or not affects any buyer's decision. Is that really a material misrepresentation of the nature of the product? Hear the courts say, well, let's take it to the jury and see what they say.
Yeah, I don't know that it is. And maybe it was just kind of that unique design. I mean, that's in my recollection.
Yeah.
So,
I do think it is a triable issue of fact that the jury could come back and say, yeah, you said it, but it, well, the testimony will come out, I'm sure. We'll have more to talk about at some point. If we choose.
And will they have to do surveys to see if people actually were misled?
Good question. Maybe they already have. We'll see. We'll see.
So, talking about misleading or potential misleading, we've got a little bit of legal lawyers in lawsuits to talk about. Lerner and Rowe PC versus Brown, Engstrand, and Shelley LLC is a legal battle unfolded over trademark rights in the digital market space, primarily running those good old Google ads and AdWords. Lerner and Rowe is a prominent Arizona law firm.
I gotta just break in here and just say, I'm just amused because the similarity to the Broadway writing team of Lerner and Lowe catches me every time I look at
it. There you go. Anyway. It does kind of sound like a group of songwriters and writers, all of these running together do. Anyway, so Lerner and Rowe, the law firm, filed suit against the law firm of Brown, Engstrand, and Shelley, which operates under the name, quote, the Accident Law Group. The dispute arose when ALG, for Accident Law Group, used Lerner and Rowe as keywords in a Google ad marketing. Google ad marketing, which is a technique called conquesting, causing ALG's ads to appear when users searched for the other law firm under Lerner and Rowe. Lerner and Rowe claimed this practice violated the Lanham Act's trademark protections and amounted to unfair competition and unjust enrichment. The District Court of Arizona sided initially with ALG, granting summary judgment on the trademark infringement and unjust enrichment claims, but it allowed the unfair competition claim to proceed. ALG later moved for reconsideration, and the District Court ultimately granted summary judgment on all claims. Lerner and Rowe appeals this decision to the Ninth Circuit. And what have we got on appeal? They looked at trademark infringement. Mm-hmm. Is the use of ALG, is the use by a competitor of Lerner and Rowe going to show a likelihood of confusion? While the court acknowledged that the strength of the Lerner and Rowe trademark weighed in the plaintiff's favor, it noted several other factors worked against the claim. And I don't know that I agree with this. Consumers searching for legal services are generally cautious and discerning. I think it depends on what kind of legal services you're searching for. That's Tamara's opinion. ALG's ads were clearly labeled, minimizing the chance for confusion. Now, again, that's if you are, I think, a savvy consumer, that you realize that all of those stacked up at the top that say sponsored are really advertisements. Evidence of actual confusion was minimal, but there was some actual confusion. Lerner and Rowe presented evidence that out of over 100,000 incidents of the ad showing up on a search of the plaintiff's names, there were 236 incidences, and I'm going to plug in here, of reported consumer confusion. Mm-hmm. The court noting that is less than 0.25%.
Yeah.
So the court cited certain precedent that sophisticated consumers are less likely to be confused by keyword advertising. I, again, don't know. Ninth Circuit upheld the summary judgment for ALG on the claims of unfair competition, since the trademark claim failed because of the lack of consumer confusion. That kind of busted the unfair competition claim as well. And then we get to unjust enrichment. The court affirmed the dismissal of the unjust enrichment claim, finding no evidence that ALG had unlawfully profited from its use of the keywords. So the Ninth Circuit affirmed the district court summary judgment in favor of ALG on all of the claims.
Now, I remember, it's a long time ago, 15, 20 years ago, but I remember there was this concept of initial interest confusion. And courts were pretty routinely finding that if you used another brand's trademark as a keyword when you were purchasing advertising, so targeting people who were searching for that phrase, that was a form of infringement. It seems that has gone by the wayside under the sleek craft.
I think it has.
Which is...
and there was, I haven't done this for a client in a long time, there was a way through the Google system that if you knew your keywords, your name, your trademark were being used, you could report it. Yeah. I'm wondering now if that's even a thing.
From the sounds of this kind of ruling, it sounds like, no, that's perfectly okay. Go ahead and bid on your competitor's brand name, competitors' names, so that...
And maybe as long as it comes up as a sponsored ad. Maybe that's a key factor there.
Well,
why would you not bid on, if you were going to pay the money to bid on it, you surely would want to be at the top of the stack as on the returned search results.
Well, if I'm Pepsi Cola and I tell Google every time somebody searches for Coca-Cola, show them our ad. Seems to me, well, I don't know.
Maybe that's because they're famous marks. Maybe that's going to be a different deal.
Maybe. There's part of me that says, well, no, consumers should be offered the opportunity. And if Pepsi's willing to pay for that, put your ad in front of them. It doesn't stop you from showing Coca-Cola's results also. But I think it's the only people it's good for is the Googles of the world, because they're charging, it can drive the cost of the advertising up, the price of the advertising up. So I don't know. It is what it is. I thought initial interest confusion was still a thing, but I guess it's good to find out it's not. I don't do litigation in this area, so anyway.
Yeah. Well, it will change. I think I just don't feel like I even have that many questions from clients anymore about it.
Yeah.
And this is probably why. Because it has completely somewhat become the Wild West.
I also agree with you that consumers searching for legal services are generally cautious and discerning. I think really overstates it. I don't think that the fact that they're labeled makes a difference either. I think if I type, if I'm in a car accident and I need a lawyer and 12 of them haven't already approached me from one avenue or another, I'm going to sit down at Google and type car accident lawyer.
Yeah, car accident lawyer, Los Angeles, car accident lawyer, Denton County, Texas.
Yeah.
And I even do that, even if I may just type, I was in a car accident. Do I need a lawyer?
Yeah. Yeah. So, so showing them the ads, the people who bid on these particular phrases, I mean, maybe it doesn't really matter in this. So you show them, okay, they searched for these keywords. Some of those keywords show up in this phrase accident law group. So we'll show them the ads.
Well, but here's the thing. So who's your big accident injury lawyer in LA?
I couldn't tell you.
Okay.
I mean, there's probably 50.
There are here too. But if I put in a search that said, I need to hire the Texas Hammer.
Yeah.
I'm going to get his firm's ad, but I'm probably going to get a whole bunch of other ads too.
Well, this is another component that I didn't see discussed in this case is accident law group is as close to descriptive as you get without it being.
Well, but I think they were searching for, were they searching for accident law group or were they searching learner? They were searching for learner and row.
Oh, okay. Oh, so ALG was the defendant. Okay.
They were searching for that. And it's funny that I can't think of the one in Texas beyond Texas Hammer, but in Tennessee, it's Ben Abbott. And
we got Larry H. Parker out here in LA.
Right. Yeah. So, if I put in Ben Abbott Law Firm and I'm in Tennessee, I assume I'm going to get their ads first, but.
Now I got to go look and see who's bidding on Gordon Firemark for entertainment law. I know it's not me.
You and me both. Yeah, because I don't think I'm at the top of the stack, but, and this is why I always scroll down no matter what I'm searching for.
Yeah, I've gotten to the point where I sort of ignore the ads the same way I do when they're on TV. That's time for the refrigerator.
Right. Yeah. So anyway, all right. Can you believe we've had over 2 years of the Copyright Claims Board reviewing these small claims?
It doesn't
infringements.
Right. So the CCB, the Copyright Claims Board, we mentioned a little earlier in the show, is this voluntary virtual tribunal that is a streamlined alternative to going to the full-blown federal court over copyright infringement disputes. So for claims $30,000 up to $30,000, they started accepting claims in June of 2022. And now the board has issued a report, I guess you could say, analyzing the first 1,000 or so claims in the board. So 2.5 years, 1,000 or just about 1,000 claims.
Just right at 1,000. It was 900 and some odd. So.
I think that, So this report analyzes those claims and tells us some interesting information, basically arriving at the conclusion that this CCB works. It's doing what it was meant to do. But it's interesting. About 2/3 of the claims are coming from self-represented individuals. About 39% of all the claims involve pictorial works, artwork, photographs, those kinds of things. Movies, literary, and sound recordings add up to about 10% for each of those. And California has the most claims. 168 of the claims came from California.
And Texas was in second.
Was it?
Yeah, I think so. You know what? I didn't check to see how many were from New York.
Right.
New York may have been second, but Texas had a huge number of them as well.
So of these 1,000 claims, most common resolution was 391 cases where the board found something was out of compliance and they rejected the claim or sent it back for try again kind of stuff. Another 153 claimants failed to serve proper notices on the other party. 91 respondents opted out, which is one of the things you can do if you're asked to participate. 79 settlements 89 voluntary withdrawals, which also mean settlements. So only 23 cases were taken all the way through to a final determination.
And I think it was even less than that. Sorry, I'm jumping over to the contested proceedings were 9 out of final determinations, and default proceedings were 14. So really, as I look at that, only 9 cases went through with a plaintiff and a defendant all the way through out of the whole time this not to say this project, this is not a project, but this court has been
the snarky, cynical part of me says, well, how much are we paying these judges for 9 cases in 2.5 years?
but then I also look at it and I say, and sorry, I'm jumping over to 391 dismissed for compliance issues. I look at that and say that probably is a win. That was 391 cases that did not get filed in the federal court system.
Yeah.
And maybe that many wouldn't have been filed because of just the barriers to entry that are perceived.
Yeah.
153 where they couldn't have service.
Yeah.
So again, that kept another 153 out of the process of moving forward.
Well, did it lead them to go and, okay, I better hire a lawyer? Or
no, I don't know. Or maybe they got that's what I don't know. And I don't know if you could parse this out either. How many of these that did not go forward were refiled again?
Yeah, that
yeah.
Another interesting thing would be how many of all of those cases were filed by the same plaintiffs? How many people rather than number of cases? I think it would be interesting to see, because I would bet that of those 168 claims in California, the majority of them probably come from the same 25 or 10 plaintiffs. And I don't know, but that would be my guess, is that there are some people who are using the system a lot, and it's the ones that they're probably the ones that have started to figure out how it works and make it work and get the notices, those kind of things. So that's something worth looking at. I didn't think to explore it until just now.
Yeah, and I haven't gone in there and dug around in a while. I appreciate. I know we've got kind of a summary here from Bailey. I can't plagiarism today. I can't. His first name is blanking on me. Yeah. He's been going in and digging around and taking a look at them. It's just the ones getting dismissed for non-compliance. I mean, if you do go in and read any of them, I mean, it is a lot, I suspect, for the judges or the paralegals over how their staff, their clerks, to weed through, because we all have been on the receiving end of letters or communications, or our clients have, where it is not a fully thought out, vetted, all the elements of a cause of action clearly on display. So I don't know how there can be an improvement in handling of invalid claims and assisting users. I don't know if that can be.
The report talks about there's room for improvement in the sense of making more resources available for the users of the system. And so better explanations of what service of process is, how to serve process, those kinds of things probably could make a difference in that arena to get more people toward a real resolution rather than further frustration with the system,
Sure. And it just makes me think back to the days of the judge's clerk or the court clerk saying, I can't advise you. I can't tell you how to practice law, or I can't advise you on this. This is out. So you just have to, here's the piece of paper.
Yeah.
And you need to read it, and you need to, you're unrepresented. So
this is a situation where a lot of it is just interpreting the statute or interpreting the rules of federal procedure or the rules that have been promulgated for this particular court. And so, I think it bears looking at the rule and saying, is this stated as clearly and simply as possible for the user to do, or do they need to have someone who's familiar with legal language parse it for them? Because I think the idea is they shouldn't have to. And small claims courts have got this worked out for the large part, I think.
I think they have. And I think you raised the interesting question of, out of all of these almost 1,000 that have been filed, how many actual plaintiffs, distinct plaintiffs are there?
It wouldn't surprise me to see a name like Higbee show up a lot in that list.
I've searched for that and there's not a lot.
Oh, is that right? Okay.
So, but I'm wondering, just even small to mid-sized or even larger businesses that are legitimately using the system to file these claims.
Right.
Or photographers who are savvy, other content creators who are savvy, who are using this to proceed. Yeah, now it makes me think, I should do a little more digging myself in my spare time. Maybe I'll sit on the beach and do that today. That's what I'm going to do.
You have spare time today, though.
Yeah, that's right. Instead, I'm reading, the second book in the Lincoln Lawyer series.
There you go.
Which happens to be series 3, which just came out on Netflix because, I'm on vacation.
Right. John Grisham's good stuff. So,
that's not Grisham. That's
Lincoln Lawyer. It's Michael Conley.
Lincoln Lawyer's Michael Conley.
Yeah. Good stuff.
Both good stuff. Yeah. Good stuff. So anyway, we will continue. I think they come out with this report annually. I recall we did an update about this time last year. We'll see what's changed if, we see a big jump.
Yep.
If we more than double in the next year the amount of cases that have been filed.
Yes, indeed.
So, and maybe we'll have some, maybe or maybe not, we could have some real life experience with it. It still seems to fall under the litigation category for me, though.
Well, listen, we've batted it around enough. I think that brings us to the end of this episode of Entertainment Law Update. And as always, a big thank you to our loyal listeners for spending your time with us. We do appreciate it. We're grateful for you. You're here. You're, after all, why we do this. And if you have feedback for us, and we hope that you do, please leave it for us. Go over to entertainmentlawupdate.com, and there's a little website red tag widget on the right side. I think it's on the right side, and you can use that and leave us a little voice message, and maybe we'll play it on the air. Or you can just send us an email. The email is entertainmentlawupdate@gmail.com, and I'm still going to call it Twitter, even though it's X. Our handle on that service is @EntLawUpdate. And Tamara, aloha. Thanks as always to you. How can listeners reach you?
And mahalo. Folks can find me online, tbennettlaw.com, createprotect.com. That'll get you to my blog, my website, everything I've got going on at createprotect.com. At Tamara Bennett on most social media, including Twitter /X and LinkedIn as well. So folks can find me there. Thanks, Gordon, and thanks for accommodating that kind of little bit of a time change for you and I, but same day, same channel. So glad to get our recording in for October.
Yeah, thank you for making the time while you're on vacation. I appreciate it. So I am Gordon Firemark from Los Angeles, and my website is firemark.com. You can email me, gfiremark@firemark.com, and gfiremark is the handle on all but LinkedIn, on LinkedIn is gfiremark too. So all but Instagram, where it's my full name, Gordon Firemark. But social media is good. Firemark, that'll get you. And let's say thank you to our volunteer contributors, the managing editor of the show now for quite a long time, and we love having him just back from his honeymoon, is John Janicek. They got married a while back, but they took the honeymoon last month. Charles Thorne is part of the team, as well as Alexis Allen and Violet Zhang. Tasha Spear and Dawson Holder are the newest additions to the team. And if you would like to become a part of our Entertainment Law Update family of contributors, reach out using that email address. It's entertainmentlawupdate@gmail.com. And that brings us to the end of this episode of Entertainment Law Update. We say thank you again for listening. And until next time, that's showbiz. Aloha.